Thank you for having me.
Thank you for being so patient.
So my pleasure. Members of the Assembly Committee on Colleges and University, I'm Dan Lennington. I'm Deputy Counsel with the Wisconsin Institute for Law and Liberty. I oversee WIL's Equality Under the Law project, which advocates for a colorblind society through litigation and policy reforms. Today, I am pleased to speak in favor of Assembly Bill 554. The United States Constitution and the Wisconsin Constitution both include a pledge of racial equality and a mandate that all laws must be colorblind. This is especially important in the field of education. Just a few months ago, the United States Supreme Court ruled that affirmative action plans at Harvard and North Carolina were illegal. Those policies granted racial preferences in admission to some races, but not others. Harvard defended the program, saying it was necessary to ensure racial diversity of the student body. But the Supreme Court rejected that argument, explaining that racial preferences are a zero-sum game, always benefiting some students at the expense of other students, and relying on pernicious racial stereotypes. In short, the court ruled that there was no justification for race discrimination in higher education, and that the so-called diversity rationale does not justify any race-based decision-making. Unfortunately, Wisconsin law fails to live up to the principle of equality. Dozens of Wisconsin programs, from grant programs to government contracting to even drug treatment programs, discriminate against Wisconsin citizens based on race. These preferences must all be reformed and open to all races. If they are not, courts will eventually strike them down, potentially resulting in damages against state officials, including attorney's fees, and taxpayers will ultimately pay these bills. Today, the legislature is considering a series of reasonable and necessary reforms to make our laws colorblind. These reforms are long overdue. The bill focuses on two general categories. One, race-based scholarships and loans to students, and two, racial enrollment incentives for certain educational institutions. These laws create racial categories based on stereotypes and then prefer some races over others. This is unconstitutional race discrimination, pure and simple. Consider two of these grant programs: the Minority Undergraduate Retention Grant Program and the University of Wisconsin's Lawton Minority Undergraduate Retention Grant Program. Under these programs, only, quote, minority students, minority undergraduates, are eligible for scholarships. White students are ineligible for scholarships, but you may be surprised to learn who is, quote, white under Wisconsin law. Students from North Africa, Egypt, Morocco, Libya, Tunisia, and Algeria are ineligible for scholarships because of their race. Those are white students in Wisconsin. Students from Gaza and the West Bank are white students in Wisconsin law. They are ineligible for these scholarships because of their race. Students from Turkey and the Middle East, students from Saudi Arabia, all the way to Afghanistan, are considered ineligible for any of these scholarships because they're the wrong race. Wisconsin law considers these students white and therefore not worthy of a scholarship. What about Asians? Nearly all Asians are excluded from Wisconsin scholarship programs. Let me say that again. Nearly all Asians are excluded from Wisconsin scholarship programs. Students who are from, or whose parents or grandparents are from, India or Pakistan, China, Japan, Thailand, Indonesia are ineligible because of their race. There are 48 countries in Asia. Only students who can trace their ancestry to 3 countries, Laos, Cambodia, and Vietnam, are eligible for scholarships. Even Hmong students are targeted by these racial classifications. While these scholarships are attempting to benefit some Hmong students, other Hmong students are actually ineligible if their parents or grandparents emigrated from the wrong country or in the wrong year. We at WIL are challenging the Minority Undergraduate Retention Grant Program in court right now. So what we were told earlier, there is litigation against the grant program right now in court. Our clients include a white man and his wife who is from Indonesia. They have a biracial child. No one in the family is eligible for the MIRG, the Minority Undergraduate Scholarship, because of their race. What about Latinos? State law only grants racial preferences to, quote, Hispanics. Hispanics are narrowly defined under state law as those from a country whose culture or origin is Spanish. This would exclude students who are from Brazil, Guyana, Suriname, French Guiana. They would also likely exclude any student who's from Jamaica or the Bahamas or Belize. Those are not Hispanic countries. In short, Wisconsin's legal definition of who is a, quote, minority simply don't make sense, even if you are in favor of racial preferences. Considering all the laws at issue in this reform package, each of them discriminates against students from the Middle East, North Africa, Central Asia, and those who are non-Hispanic Latinos. The solution, however, is not to just add more racial categories. All racial categories are illegal and would be unworkable even if they were permissible. More importantly, racial distinctions are just plain wrong. It is a sordid business divvying us up by race, the Supreme Court once wrote. All racial classifications are pernicious and demean the dignity of individuals. The proposed bill fixes these laws and erases the racial preferences. And instead of eliminating these programs, the bill wisely opens them up to all students who are disadvantaged. The bill considers students as they ought to be considered, as individuals, not members of racial groups. Will strongly supports programs that benefit students based on their individual needs, not on racial stereotypes. Today's bill takes an important first step in making our laws colorblind as required by the federal Constitution and federal law. I'd be happy to answer any questions, but first I wanted to answer one question that was asked before by you, Chairman Murphy. Is this necessary? Absolutely, it is necessary. These laws are illegal under the Harvard decision today. Today, they are illegal. The Harvard decision said that laws that have racial classifications are only justified if there's a compelling state interest. The compelling state interest that Harvard used was racial diversity of the student body. The HEAB, the Higher Educational Aids Board, the Wisconsin Department of Justice have been in court right now and said that the justification for these programs is racial diversity. The Supreme Court just said that is an unconstitutional rationale. That rationale does not hold up. So in the rule announced, yes, those decisions were about 2 schools and 2 admission programs. But the rule announced applies to all these racial classifications under state law. I welcome your questions.
Thank you very much. And I have to say, I try not to play Supreme Court justice and try to figure out what the law is from a constitutional standpoint. On the other hand, we take an oath to uphold the Constitution, so we have to try to have, at least a decent basic knowledge of the working of the Constitution. And on one hand, we have people suggesting today that, well, because it absolutely hasn't been found unconstitutional yet, that we shouldn't do anything about it. And I would reverse that and say, if we were planning on making a law, would you make a law that you thought was unconstitutional to begin with? You wouldn't. And so that's to me, where I see us sitting right now. The representative that testified before you talked about a school district in Mequon, I think it was, Mequon, Thiensville, trying to hire teachers from historically black colleges. Mm-hmm. I'm just wondering, how does that play into this? And are they still...
Absolutely, they could absolutely do that. Historically black colleges are not colleges that admit people based on race. There are historically black colleges that are majority white. There are historically black colleges that have a huge diversity of races. They're historically black as a matter of history. They are forbidden from using race as a factor in admission because that's what the Constitution says, and Title VI, which you can lose federal funding if you discriminate based on race under Title VI, including all your student loans. So they cannot discriminate based on race, and they do not discriminate based on race.
When you were describing the different ethnic groups and who qualified for government programs, who didn't, I have to admit I've never looked at it that closely or thought about it that closely. And as you start laying out who qualifies, who doesn't qualify, it really makes me understand that once you start going down this road, it's perilous.
Exactly. The Supreme Court actually said in the Harvard decision that the very racial categories that are used here in Wisconsin law, that those automatically are unconstitutional. You can't just say Asian. What do you mean by Asian? There are 48 countries in Asia. Are you saying someone from Turkey is from Asia? Are you saying someone from Russia? Russia's in Asia. Are people from Russia Asian? So every time you try to make a category, you demean people. You say that I'm lumping you in. I'm saying that someone from the Philippines is the same as someone from Japan. Even the category in state law for Black Americans would exclude African students who are here on visa, who are Black yet not American. They're here studying. They're ineligible for the scholarship because they're not Black Americans, but they happen to be Black and they're from Africa. So it just shows how ridiculous the categories are, that once you start defining someone, you just demean them because you're putting them in a racial category instead of treating them as an individual, which is how we ought to treat people. We should treat people how they come to us and their individuality, not based on the color of their skin or where their grandparents came from.
I was actually thinking about person who testified here today, a friend of mine who was testifying today, has a wife from Trinidad. And I was trying to figure out, she's Black, but is she African American? Would she fit into the criteria that's out there?
It's a difficult question because a lot of these colleges, they say, how do you identify? And I read a story about Jamaica a few weeks ago, and it was several people from Jamaica were disputing the labels African American, and they were disputing the label Latino, and they were saying, I'm Jamaica, I come from a country that is English speaking, I'm not Hispanic, I'm from the Caribbean, but I don't like the label Latino, I don't like the label African American, I don't like these labels, I want to be known, I identify as something else. And I've heard other people who have different races or who are biracial, that every time they see a form and it says check the box that your race is, they feel a harm to their dignity. They say, I don't want to check a box. I don't fit into any of these categories. And that just shows the nature and the danger of putting people in boxes and treating them as certain minorities. There's a harm you can cause to them in their individual dignity.
I always find the term Hispanic rather problematic because there's a tendency for Americans to look at everybody, south of the border as being Hispanic. Mm-hmm. Hispanic really means, Spanish.
Yeah, I read there's a book about this. The word Hispanic was invented by the Nixon administration in the 1970s, and nobody considered themselves Hispanic before 1972, and that it is not actually a racial label, it's an ethnic label. There are over 50% of Hispanics are white. Okay. That's why when you see these boxes, you have to check white, Hispanic, white, non-white Hispanic. Mm-hmm. It's because it's an ethnic category, it's not a racial category. So just, again, it shows the absurdity of putting people in boxes, and why can't we just help? If the legislature would like to help people who come from hard backgrounds, mm-hmm. What does disadvantage mean? I know it's not defined. How about what zip code you come from? What neighborhood you come from? Did you come from a broken home? Was your dad in prison? Were your parents divorced? Were your we can go through and figure out the disadvantage of people and what leads to economic unsuccess, and you can identify those factors. And you can say, these are the factors that lead to someone to be unsuccessful on average based on statistics. And you could say, these are the categories we would like to give, a benefit to these people who are disadvantaged.
I think sometimes we get into the mindset that somehow we're changing the law, so everybody who was, getting some kind of a scholarship or grant or whatever before, now is automatically going to be kicked out, and somebody else is going to replace them. And I think that certainly is not true. Many of the people who are getting this today would probably continue to get it. Not all, but I think a good share. And then there may be another group over here that's very disadvantaged. And though their skin color doesn't match the program over here, now would become eligible. Am I seeing it correctly? Or?
Yes, and I would say it is. The legislature has the authority to write the law and define what disadvantage is. The legislature does delegate to agencies many times, although we're not a fan at will of delegation. But the idea that the legislature should be able to write their own laws. But if the legislature would come up with a definition of disadvantage and hardship, it's not difficult, and you can do it in a way that does not refer to someone's racial category, because there certainly are people who are minorities in this country who are not disadvantaged. There are certainly people who are white in this country who are disadvantaged, and so it's not an automatic one for one.
One last comment that I have, and it's always concerned me that we are trying to fix the problem with poor education for minority students when they get to college. Instead of fixing it, starting at kindergarten and doing it right in the first place, and making sure that when these students graduate from high school, they're prepared to go to college, number one. And then if they are disadvantaged, then we need to help them. And that's the way I look at it. And I don't know, maybe it's too simplistic, but that's... I don't know if you have any comment on that, but I would look for... anyone else on the committee have any questions otherwise? Representative Johnson. Now, if you want to make a comment, go ahead.
No, that's fine. No.
So you have a suit pending relative to representation. So if we pass the bill as it's written and we don't define disadvantage, am I just looking forward to another suit coming that's going to say, well, they are choosing disadvantage and we disagree with that terminology that they're using?
The equal protection problem with disadvantaged is solved by this bill because it says that disadvantage cannot include race, religion, sexuality as a factor. There's a number of characteristics that you can't include as a factor in what disadvantage is. And it does leave the agency up to define what is disadvantaged. So I would say there would not be a lawsuit saying, disadvantaged. The word disadvantaged at the federal system, with the Small Business Administration, with the U.S. Department of Transportation, with lots of different federal programs, that race is cooked into that word. And so when you hear President Biden talk about disadvantage or socially disadvantaged, he's talking about race. Because federal law defines if you are a certain race, you are automatically disadvantaged under federal law. Actually, if you are a woman, you are disadvantaged according to the Biden administration, automatically, no questions asked. So the word disadvantage at the federal level does have a female and race baked into it, but this law makes clear that race cannot be baked into the definition of disadvantaged. But yes, would I prefer that the phrase disadvantage was defined? Yes, and I could offer some suggestions. I do think the representative said that need would be one of the factors, and I think need is a very good factor. Family income, economic hardship, that sort of thing. I do think there are ways to tailor remedy to certain geographic areas that are disadvantaged, neighborhoods that are disadvantaged, neighborhoods that lack economic advantage, people who come out of there. are at a disadvantage. I think there's lots of ways to define that term and lots of factors to go into that. I'd be happy to talk to anybody about that.
Statistically, from the employment records, short people are disadvantaged. They get paid less than tall people.
Yep, there are lots of disparities in this country. One of my favorite ones is birth order. A firstborn has a higher IQ than the thirdborn.
You're not very lucky, are you?
There are certain massive disparities based on geography. 6 out of 10 of the poorest countries are in eastern Kentucky. There are all sorts of disparities created by things that are non-racial.
With the current law, how finite does it define who can receive these, in this case, scholarships?
Under current law, you have to be a member of these certain racial categories to get these grants. So the very first line of the minority undergraduate grant statute says in this section, quote, minority undergraduate means an undergraduate student who is 1, Black American, 2, American Indian, 3, Hispanic, as defined somewhere else, and 4, a very narrow type of person whose ancestors came from 3 countries in Asia. So if you're not on that list, you're out of luck.
Thank you. No more, Mr. Chairman.
Then we will go to my friend Representative Stubbs, who I think might qualify as being short. I don't.
And strong. I've learned so much today. Women, all kinds of things. That's a process. Thank you for being here. I have a couple of questions based on your testimony, and I think Representative Johnson started where I wanted to go, because the bill author in this bill, there's no definition for disadvantage. I heard you started alluding to the factor of considering family income, family hardship. If you are supporting this bill, did you spend time with the author to try and help him think about suggestions around the word disadvantage?
I would be happy to do that. I think there's lots of studies out there that talk about disadvantage and economic, let's say economic disadvantage, I think is probably the best word. And I think there's lots of ways that we can approximate a series of criteria that will get at hardship. I think that there are young boys and girls in this state that grow up in neighborhoods that they have a far more disadvantaged background, a monumentally disadvantaged background than my children growing up in Oconomowoc. And I feel bad and horrible for those kids that they will not have the same advantage, that they don't have the same access to education, they don't have the same access to teachers, they don't have safety in their neighborhood, they don't have a police force that protects them, they have to see violence every day, they have to see domestic violence. That saddens me, and I feel that's disadvantaged, and I would like to be able to put that into words with certain criteria that explains, if you're one of those people, we want to lift you up. We want to give you a lift up from there, and we don't want to treat you as someone who belongs in a racial box. We want to treat you as an individual, and we know you've had hard times, and we know you come from a bad place, and we want to lift you up. That's what I view when I see disadvantage, and I think that could be put into legislation.
Okay, so I would employ you to meet with the author, because he didn't bring a definition, but it sounds like you've been thinking through this process and could be helpful there. I want to go back to some of your comments during the testimony. You talked a lot about, and you did a good job to talk about a minority undergraduate and the definition, but throughout your testimony, you talked a lot about race, but then in this bill, the bill identified who is a subject of that race. It was kind of interchangeable. I wish that when you had testified, you could have been specific about where in the bill you were trying to define who you were speaking about, because I know you talked a lot about different parts of Africa and, Trinidad or Jamaica, wherever, yes. But throughout the bill was very specific about definitions, mm-hmm. And I think part of your testimony sometimes could be misleading as you were talking about minority groups, that it was very specific in the bill. So that was just my own personal comment. I'm glad I read the bill, so I kind of was following what you were trying to allude to. It wasn't a question, but it was a statement that I was making, because I think it's important for those that are listening or viewing that don't have the bill in front of them. It could be misleading with some of your comments that you've made.
Yeah, I appreciate that, and it is very confusing as far as the racial categories. And so, attached to my testimony, I have an exhibit that lays out each of the statutes that are being reformed today, as far as proposal, and what racial categories they each have, and they're not the same. You could be eligible if you're a certain race in one statute, but not in another statute. And it goes through, in my testimony exhibit, each statute, and goes through each racial category, and says, how does Wisconsin law define these, quote, minorities? And it's usually very different, actually.
And my only other comment is, have you had an opportunity to be in discussion with someone that was a person of color? We'll just use that, of race. And, we've talked about Jamaica, Trinidad, other countries. What did they select on their application? Did they select African American, Hispanic? There's an other box. What did they select?
I just yesterday had a conversation with a woman who's biracial, and she was telling me how going through this process of checking the boxes since she was a young girl had harmed her, had she felt it was a harm to her dignity as an individual, that she had to choose a certain box, even when it didn't say biracial, and that she had to choose, am I black or am I white? I did not ask her. I did not push her. I said, well, what box do you choose? That would defeat the purpose of the entire conversation. She was telling me how she didn't want to choose and how it hurt her to have to do that, and still today has to choose the box. So I just wanted to reflect that I have had that conversation, and that I can't understand what that feels like.
Well, I can, because I'm a person of color.
Yeah.
I certainly can tell you that. And the reason I asked you that question is because I think with your testimony, you spoke a lot about race. And I think if you're going to come to this committee and have those discussions, give us some examples of reality, because I think people do sometimes have to pick and choose. My husband's from the Bahamas. He can choose African American, or he can choose other. Those are options. Or you don't have to choose anything, right? But right. I think when you're given that testimony, people still have choices, right? They don't have to do it. And sometimes it is difficult based on where you grew up, based on what you're going through, based on how you feel. Sometimes you feel connected or disconnected. Depends on where you're talking about your ordinance. So I think there are different experiences. There is no right answer, but I wanted to push you there in that area because you are here talking a lot about race and the impacts and not impacts. And so I wanted to just hear you elaborate what that was like as you're in conversation.
Yes, and we have at will-law.org, we have a video of one of our three of our clients. I just talked about in my testimony, one a woman from Thailand, and two her husband who is white and their biracial child, and they talk all about their experiences. I mean, what I litigate every day, what I'm in court every day, is about race. That's what I do. I do race litigation all day long. So I do talk to these people. I do talk to clients, and what I can say is that our goal at Will is to bring our laws to a point where people are not considered, or there's not some assumption or stereotypes about them because of their race, but that everyone is treated equally as an individual, and they're based on their own merit and their own individuality, which is much more interesting than any sort of category you could put someone in.
So if choosing race is about choice, then why can't I choose to be black?
You can be whatever you want to be.
Doesn't that completely defeat the purpose of what the law is to begin with?
You can be whoever you choose to be. That is your choice. We live in a country where there are choices. But I'm just saying I have a choice when I fill out an application, what I want to put on there. You can put on there if you have been incarcerated. That is a choice. I am saying I make these choices every day. As an African American, I make those choices. That is a reality. I don't have to look for people.
Well, if you put down that you haven't been incarcerated and you have, then you're lying.
I said that our people choices. It's called ban the box.
Well,
you don't want to go in the criminal justice arena. I'm an expert. But it's called ban the box.
you could do that, but
There's
if
the
your choice
attorney.
is to say that you're not incarcerated when you are, then you're lying.
It's called ban the box. It's the
Well,
law.
no, it's lying. It's not being the box.
Do you know what that is? Ban the box.
I
There's
do.
an attorney.
I absolutely.
Ask her what it means.
I know what it is. Does anybody not know what that is? No? Everybody knows. Representative Johnson.
If we go to defining disadvantage, don't we start eliminating people who would be eligible under someone's thought of disadvantage? This question might also go to alleged counsel, because I'm thinking that the way, I mean, there's been pushback today about the lack of definition of what disadvantage means, and maybe the writing of the bill was to leave that broad spectrum so that it would be more inclusive rather than exclusionary, because that apparently is what the bill is trying to do, is to avoid excluding people. Again, the question is, to either one, if we go about defining disadvantage, do we start to eliminate potential people who would qualify?
So for purposes of administration of the program, someone will have to define disadvantaged. I think the question is whether that's the legislature or the agencies overseeing the programs.
Your comment.
Yes, I think the legislature defines words all the time, and sometimes someone could see a word that in common meaning means X, and the legislature has defined it more narrowly. The legislature does that all the time when they come up with definitions, and a lot of times the legislative definitions are actually more narrow or more broad than we might use in common parlance. But I don't think that if you define the word disadvantage, and then someone says, well, I think someone else is disadvantaged, that is legally relevant. But the way if you want to have hard lines, we have lots of programs in the state based on need, and you can just define need. You can just define need as a certain number. But disadvantage is more of a modern way to do it, and a lot of federal programs use the phrase disadvantage.
Thank you. No more.
Representative Nedwesky.
Thank you, Mr. Chair. Thanks for waiting so long, Dan. Appreciate
You're welcome.
it. In the context of the bill and looking at the exhibit in your testimony, which I just opened up, so I haven't fully dived in. For each of the options, you were discussing how for every program there's a different set of eligibility. They're not all the same across the board in terms of who would meet the criteria for each program to at least be eligible to be awarded a grant or a loan. So in any of these, is checking the other box an option for eligibility?
No, because there's other is not an eligible factor under these racial categories. People must belong to must at least identify as belonging to certain categories to be eligible for the scholarship or the benefit in the first place. So clicking other does not get you to eligible for the program.
Must identify it? So if I identified as Hispanic, I could qualify?
That's what the position of the Wisconsin Department of Justice and the HEAB is, that these are for people who identify as these. I know people have discussed this phrase transracial in sort of as a joke. I don't know if that's really something that people do, but as far as they say, if someone feels like a certain race, they can check that box. That's at least the part of the government's position right now in litigation. I don't know how that works out in practice. I guess it works out in practice easily because the person who's accepting the application just looks at the box and they just say, well, the person checked American Indian, therefore I'm just going to assume they're American Indian. I'm not going to do any interrogation of them, which is probably a good thing. We don't want government officials interrogating someone about whether they're really a certain race or not. So I don't know how to crack that nut, but right now it is how do you identify, as is the government's position.
So would it follow then that like what Representative Stubbs said, you can be whoever you want to be, and you could literally apply for one of these programs and check a box, something that you're not necessarily outwardly appearing as, but you could say, well, I identify as Hispanic, and therefore I'm qualified.
I think that's the position of the government right now and the position of those who interpret the laws. I don't know how to get around that
Okay.
issue apart from.
I didn't know that. Well, that was
Yes, I
very
think it would
interesting
be
enlightenment.
sort of like interrogating someone about their gender. I mean, it would be very difficult and damaging probably to do that to someone emotionally. So I think probably I would prefer not to have government officials trying to determine whether someone's really telling the truth about their particular race or not, unless there was some actual evidence of fraud.
Interesting. Thank you so much.
Any other questions from committee? Seeing none, Dan, thank you very
Thank
much. Interesting.
Thank you.
So